happy Friday, Fran McGovern. Nice to see everyone again. And we have Heather McLean with us today, who's one of our other attorneys, and we're going to jump right in. So today's title is Board Member Indemnification and Board Member Civil Wars, right? I'm sure everyone's board operates in perfect harmony out there. You all love each other and you're all there for the single mission, right? For the benefit of the community. God bless America, right? But that doesn't always work out that way. Let's talk about the dog of the day for a second. So we did get 2 submissions for the dog of the day today. We're going with the first one, and we'll get to the next one next month. So this is Reggie. He is a yellow lab. Unfortunately, if you see there, Reggie, he broke his leg, unfortunately, when he's 4 months old, but the cast is off now. Like I said, he's a golden lab, and apparently, like golden lab puppies, he's fixed, healthy, and running all over the place and going nuts now, right? That's golden labs do that. And he belongs to Michelle Phillips. He's Michelle Phillips' grand dog. And for those of you who know Michelle, she's been a manager a long, long time, both in New Jersey and out in, I believe, in Phoenix area as well. Michelle works for Taylor Management, and she is the manager at Strickland Farms Condo down off Route 9 there. And Michelle also has she is so lucky, she is married to the legendary Jim Hanley, who is a legendary manager in New Jersey and also works for Taylor. So anyway, that was Reggie, beautiful dog. And now we have to go into the legal announcements, right? Since I'm a lawyer, since no attorney-client relationship. These seminars, if you will, are only for educational reasons. No, this is not actual legal advice. To get legal advice, you have to go and find an attorney or sign up with us, which would be a beautiful thing too. And we will give you real legal advice. These are just for educational discussion purposes only. Nothing will be held confidential, as you know, so don't ask me any secret questions about the evil board member that you hate on your board, right? So be careful, don't send anything in the chat that would be too funky. But feel free to post questions in the chat if you'd like to, and we will try to answer them. So oh yeah, a reminder, Eileen tagged this onto the agenda today. Thanks, Eileen. The Dog of the Day calendars for 2023 are available. Most people should have gotten them. We take all your information, and we actually do keep that information, and we do mail out Dog of the Day calendars for the forthcoming year. So 2023 have gone out. If you haven't gotten one, please email us and let us know, and we will send you the Dog of the Day calendar. So why is Fran McGovern talking about, oh my gosh, this board member civil war and nonsense? What's happening? Well, there's a new case that came out last week. It's the Ocean Club case, and we'll get to that in a minute. But is board membership all risk and little reward? Maybe it's all risk and little reward, but it really, as you know, it depends what you make of it. Of board service, it depends whether or not you use your property management team the right way, or do you just torture yourself by trying to manage the community yourself, right? Which is not the case. Everyone knows the model should be the association's board sets policy, the management team implements that policy day to day, okay? So that's typically the way it works, and it should, at least the way it should work. So it's not all risk and all reward. It's something that really, really benefits the community, and it makes my job possible, right? If we don't have a good management team, if we don't have good board member volunteers, I can't do my job, and the membership scratches their head and says, why are we always in lawsuits? And oftentimes it's not the lawyer, it's because things are not going right at the board level, or things are not going right with the management team. So again, good board members, awesome. Good management team, awesome. That really controls your attorney fees, which is a beautiful thing. So the New Jersey Supreme Court, when they're talking about indemnification with respect to board membership and board function, what is the purpose? It encourages talented individuals to serve as corporate leaders, right? Because who in their right mind would serve on an association board if they were putting their personal fortune at stake every time they made a decision or did not make a decision, right? So indemnification, defense, and hold harmless makes it so that you can volunteer. You're smart people. You've dedicated time and energy to your community. And if something happens where someone names you in a lawsuit or comes after you in a lawsuit, you will be able to turn it over to the association's either association expense or the association D&O insurance carrier. All right. Board member indemnification. Board member indemnification means that essentially the association will take the hit instead of the individual board members taking the hit in a lawsuit, right? Again, otherwise you would never serve on the board. What is board member defense? That means the association will pay the board member's attorney fees in defending the claim against the board member, so long as those claims arise out of the board member's duties and the board member wasn't acting in what would generally be called bad faith or self-dealing, right? So the association is not going to defend you if you are stealing from the association and someone sues you for that, right? So bad faith, if you do bad things, or if the suit is outside the scope of your board duties, you're not going to be indemnified or defended. But in most cases, in the vast majority of the cases, if you are doing something within the scope of your board duties, you will be indemnified and defended. Hold harmless, same thing. Very helpful, because what you don't want is the association goes and indemnifies you and defends you and pays your attorney fees, and then the association itself sues you back for reimbursement for all those costs and expenses. So that is hold harmless, which means even though the association absorbs all these costs, we're not going to come after you. We're going to hold you harmless for that cost, right? Because you don't want it to circle back and bite you in the hiney, even though you were indemnified and defended on the front end, right? You always want to watch your hiney. So in this case, how do we doubly protect our hiney? We cover insurance. We buy insurance to pay for these types of issues. And that's usually called directors and officers insurance, right? So directors and officers insurance, very, very important to have. You must have it. Otherwise, the association is going to wind up paying for these expenses out of its own pocket. Some people are under the impression that if there is not D&O insurance, the association will not be obligated to indemnify, defend, and hold the board members harmless. That's not true. The governing documents would still require that the board members be indemnified, defended, and hold harmless. There would just be no insurance for it, and the association itself would have to pay the attorney fees as well as any damages. And the associations would have to pay that, unfortunately, via a special assessment, because those costs would never be in any budget. Does that make sense? You wind up taking the hit yourself. So make sure that the association has directors and officers insurance. Third-party claims. So when we say third-party claims, we're talking about when somebody other than a board member, right, sues the association or sues the association's board member, right? So a typical member, a guest in a community, a service provider, what have you, a third party other than another board member sues the board members, sues the association. That's your typical indemnify, defend, and hold harmless, right? Which makes a lot of sense. Hey, we're the board members. We're running this place. And if we're running this place and someone makes a claim and we're doing it in good faith, we should have coverage for that. The association should pick up any expenses for that. So that's third party. That means non-board members suing the board and the association. First party claims, this is really weird, right? This is the case that came out last week, is first party claim is when a board member is suing his own board or her own board because of issues growing out of his or her board membership, right? Which we rarely see this issue. But I will say that this case that we're going to talk about in a second, in some ways, is terrifying. Okay. So that's a first party claim. That's where you're sitting on a board and someone says, we're going to remove Kenny from the board. Let's take a vote to remove Kenny. We all hate Kenny. Get him out of here. And there's a motion and a second. We go, there's this wonderful thing called Radburn. We're going to do Radburn. We'll give him a chance at ADR, but we still hate Kenny, notwithstanding the ADR, get him off the board. And they remove him. The board removes him. And then Kenny says, whoa, wait a second. I deserve to be on the board. I'm going to sue the rest of the board members for throwing me off the board because you did it the wrong way and there was no justice in the removal itself. And that is, excuse me, very close to what happened in the cases generally called Boyle versus Ocean Club Condominium Association. Boyle versus Ocean Club Condominium Association. And we can send you a copy if you'd like a copy. But the caption is Boyle versus Huff also because Carol Huff was one of the board members that he sued individually. So Mr. Boyle apparently was a board member. He was elected. He was ultimately removed. He sued the association saying, hey, sued the association and the board, saying I was wrongfully removed. You got to put me back on the board. And this just wasn't right. I was railroaded. Okay. So they fought over that. You know, lawyers like to fight over stuff. They fought over that. And ultimately, there was an agreement to put him back on the board. And he went back on the board. It was settled. Then he said, well, wait a second. It's not just about me being put back on the board. Now I want you, the association, to pay for my attorney fees that I spent in suing the association and the board members. That's a first party claim now, right? And all of us should be cringing right now, I believe. Okay. So there's two ways to look at this. One, you know what I'll do? I will put up the indemnification language from the governing documents in Ocean Club at the time. I don't know if it's changed or not. Bear with me 1 second. All right, and then I'll read it to you. The association shall indemnify every trustee and officer, his or her heirs, executors, and administrators against all loss, costs, and expenses, including counsel fees, reasonably incurred by him or her in connection with any action, suit or proceeding to which he or she may be a party by reason of his or her being or having been a trustee or officer of the association, except as to matters as to which he or she shall be finally adjudged in such action, suit or proceeding to be liable for willful misconduct or bad faith. Okay, I'll leave that up there for you for a second if you want to read it. So the trial court said, this is a very simple case, people. I'm reading the language. Mr. Boyle sued you. Okay. He sued you for issues involving in connection with his being a board member and former board member at the time he was removed, right? So he was a former board member at the point I believe he brought suit. Therefore, you're paying his loss, costs, expenses, including counsel fees, right? So the trial court said, yes, you win, Mr. Boyle. And the association said, wait a second, we don't feel this is right. We're going to take this to the appellate division. This appellate division said, you know what's weird? We're judges too. We're reading the plain language. It says what the trial court says. You're indemnified, defended, etc. And you got to pay Mr. Boyle's attorney fees. Okay. Which, based on the straight up language, at least to my reading of it, that makes sense, right? The issue arose out of his board membership or former membership on the board. He felt like he was wronged by being removed from the board. Ultimately, the association consented to putting him back on the board. So there's a very good argument that he was successful on his claim, whether or not the association acknowledged that. There is an argument that nobody was successful in the claim. The association just put him back on the board because they don't want to litigate anymore. But obviously that wasn't successful, really. And there's still an argument that that wouldn't make his attorney fees go away. From a policy standpoint, the question becomes, is that provision I just read a good thing or a bad thing? And the answer is you really don't know, right? Because it's a good thing if you have, and we're just making this up, if you have a minority position where the majority on the board is totally screwing around, right? Totally screwing around. The majority of the board is totally screwing around, doing the wrong thing. And that lone wolf out there is saying, wait a second, this is not right. This is not right. You got to do things right. And if you don't do things right, I'm going to sue the association and the board members, and you're going to pay my attorney fees. So that's it's good in that way. And I can tell you, for those of you who know, I don't know if you know Damon Kress in office. Damon spends a lot of time litigating transition issues involving board members, whether they're homeowners association board members, but oftentimes, and this is going to be an interesting wrinkle in the board members' provisions of the governing documents. What about developer appointed board members? What about them? Can they try and run this way too? Perhaps, we don't know. But so anyway, Damon and I have been going back a little bit over whether or not it's a good thing to have this provision or not a good thing to have this provision. It's a good thing when you have a board that's doing the wrong thing and a minority board member says, you got to stop that. I'm going to sue you and you're going to pay my attorney fees for making it right. So that's a beautiful thing. The bad thing is, right, when you have, the term, the wacko board member who sues or claims to be suing or threatens to sue every time they don't agree with the board, every time they don't agree with the way the ballots were counted for their election, every time they don't like the way the vote went down in the procedure for approving the painting of the shutters green versus black, every time they feel that the minutes weren't kept appropriately and you need to amend the minutes. And if you don't amend the minutes the way I say the minutes should be amended, I'm going to sue you all. Right? We've all heard those arguments. That's what terrifies me. I like the provision when it comes to, hey, bad board, minority member makes the board the right thing. I love that. That's great. But it's so risky given the fact that we have so many boards that have at least one member on there who fall into the wacko realm. Right, where they're just threatening, bullying, making threats against management, making threats against the board as to how the board functions. So that's very nerve-wracking to me. So that's a first-party claim, and that's what the Ocean Club case is about. And both the trial court and the appellate court just based their decision on the language of the bylaws. So interestingly, the Nonprofit Corporations Act, at section 15A:3-4 speaks to this issue. And as best I can tell, the Nonprofit Corporation Act would have supported the outcome of this case, again, based on the language in the bylaws. There's even an argument, and I didn't see this argument made in the case, that, notwithstanding the language in the bylaws, since arguably Mr. Boyle was successful, the statute alone may have made, this wasn't what the case turned on, may have made the association indemnify him. So it could go with the plain language, which is what the Ocean Club case did, but there's also a provision, like I said, under the Nonprofit Corporations Act. Now we get down to the directors and officers insurance coverage, right? Let's talk about that for a second. Directors and officers insurance coverage, as I said before, directors and officers insurance coverage should kick in on behalf of the association and defend the association on the lawsuit, which it did in this case. So my understanding is, and this was not my case, I did not handle this case. My understanding though is from people who were involved in this case, is that the association's D&O insurance paid the attorney fees in defending the case, which that's your typical D&O claim, right? Somebody outside the world pays the attorney fees to defend the association. The question becomes, as we get to the next paragraph there, Boyle versus Ocean Club condo, and I don't know the answer yet, and there is an application for further appeal in this case. Who paid for Mr. Boyle's attorney fees? We don't know the answer to that yet. I don't know, like I said, I wasn't the lawyer in the case. So the D&O coverage pays for the defense on behalf of the association. An award comes down that says under the indemnification provision, the association must pay Mr. Boyle's fees. Who pays that? We don't know. I mean, oftentimes the D&O carrier would pay for a successful claim, but will it pay in this case? Not sure. Why is that so important? For those of you who have read the Boyle decision, the attorney fee application and award was in excess of $500,000. $500,000. Oh my, sign Mr. Boyle up, right? So that's the problem, right? That's the problem with this type of indemnification language. Not only will, with this type of outcome, what I'm concerned about is, will it encourage, we'll say, dicey board members to raise these types of claims? Will it create a cottage industry for attorneys to jump on representing people like that with the idea of securing attorney fees from associations for these types of cases? That is very scary to me. No disrespect to Mr. Boyle's attorneys. Okay, it looks like Mr. Boyle was successful, but will it create a cottage industry for attorneys in this field? Big concern. I don't know the answer. So the next question is, should we amend our bylaws to limit the indemnification provision to third-party claims only? Should we do that? Would that be effective? The answer right now is, it's a policy decision for every board, right? It's a policy decision for every board, and every board, I think, is going to have to look at its own indemnification language, because it is different. I mean, in some associations, there may be uniform indemnification language. For example, if you have a Hovnanian association, perhaps many of the indemnification language was just cut and paste from one set of governing documents to another. So you may have a good sense of what the language is like. The management company people may know what it's like. So you have to figure out whether or not you're going to limit it to third-party claims only, number one. And number two, whether that will be upheld in a court if it's challenged. My answer right now is I'm not sure, because if I was the board member, if I was Mr. Boyle's attorney, I would argue, I don't know if I'd be successful, but I would argue that even if the governing document section was limited to third-party claims only, that the Nonprofit Corporation Act gives the court enough room to award attorney fees anyway, because Mr. Boyle was successful in his claims. So if the board was conservative and they said, hey, we want to prohibit first-party claims, they could try amending the governing document and see what happens. But there is no court case that I know right now that involves that type of amendment. And whether or not reading that type of amendment together with the section of the Nonprofit Corporations Act, the court would be prevented from awarding that type of indemnification to a board member. So very, very funky, very, very funky. And in my world, very scary, because you know, I don't want to see attorneys running around suing associations all over the place with the idea that they will be able to have their attorney fees recovered via the association itself. And there are too many people. I mean, the vast majority of board members are awesome and productive, but there are too many people on, as a rare exception, who wind up on boards and they're there as nihilists, if you will, nihilists, in that chaos is their aim. Chaos is their aim, and they're not really there to help, they're there to hurt. So it's a big issue right now. I think we're going to see this developing in the law. If you had me guess, this will be an application for cert before New Jersey's Supreme Court. My guess is, and you know, Damon and I were kicking this around this morning, I think that, and I think Damon agrees with me, that the New Jersey Supreme Court would not even grant cert to this because the language is so clear. They would just deny even having a hearing on this. They would say, hey, the language is what it is, the appellate division's right, go away. We're not hearing it. The court, which means it's automatically upheld. So we don't know how this is going to play out. I think it's worth, especially if you have a community where you have particularly troubling board members, two things. I think you should think about amending your documents and at least trying to see if it's enforceable. I also think that if you are working under the Radburn framework, whereby the association, historically since Radburn 2017, has attempted to or removed board members via board action only rather than a membership vote, probably not do that. Probably not do that. That procedure, even though it is still legal and appropriate, in my mind, has become much more risky because then there's always a claim that the person would have been removed improperly, and you may wind up paying the price for that. We do have some questions. Let's see. I know this is kind of dry and legalistic today, but let's see. Oh, I see. Yeah. Was he removed according to the bylaws or just by an act of the board member? So initially what happened was he was removed, I believe under the Radburn procedure, more or less, by an action of the board. And then he challenged that, and the association backed off a little bit and said, okay, no, we're going to try and remove him via the membership vote process in the bylaws. But then for some reason, I don't know the ins and outs of this, the board more or less abandoned that process, and instead put him back on the board and more or less abandoned the fight, if you will. May I assume any award would be paid directly to the attorney and not the board member, or would that be stipulated by the court? So that's a good question. Some portions of the case were reversed by the appellate division, and there are very nuanced issues regarding derivative actions and attorney fees, because they have to parse attorney fees. But one thing that the court did say at the appellate division was the only thing you get attorney fees for is for money you've actually paid the attorney. I know that sounds odd, but so what would happen, to answer Anna's question, is the client has to certify to the court that I paid Mr. Jones, my attorney, or Mrs. Jones, my attorney, X number of dollars, and therefore I'm being reimbursed. So it would typically be a reimbursement issue. But there was some funky back and forth, and some of that issue has been returned to the trial court. Does that make sense? I know that was kind of a very kind of legalistic presentation today, and I like to think I'm usually more fun, and today wasn't exactly joyous. But I wanted everyone to be aware of this case because I think it is going to come up a lot. I think we have to start thinking about amendments with respect to it too. And I think you need to dial in with your D&O carrier and make sure that if an issue like this comes up, will it be covered, right? Will the various board, et cetera, be defended? And who would pay the award from the first party claimant, right? Wait a second. I have another question here. Sorry, I'll keep going. This doesn't apply to the topic discussed, but can a bylaw be overridden by a resolution rather than amending the bylaw? So that's a good question. So generally speaking, a bylaw provision cannot be overruled by a resolution, right? You typically have to amend the bylaw itself. Resolutions can't override a bylaw. There are some little wrinkles on that under Radburn. So Radburn basically said the certain provisions in the bylaws can be amended by board resolution if it's only to bring the bylaws into compliance with the Radburn law itself. Does that make sense? That makes some sense, right? But basically you can't overrule the association's bylaws provisions. A resolution, board resolution, with very few exceptions, has to be within the scope of the board's powers in the bylaw. I'm aware of a case that a board member sued and won against the board for removing him. D&O did pay the board member that sued, but did not pay the association after lost. Oof-ah. So that's not good. We don't like that. So if you know of that case and that was an actual decision, please send that to me. I am aware of this Ocean Club case, and there was another case, not an association case that I read from before, which involved non-association law, but it was there was an analogy to that. So Janice, if you're aware of that case and you have a non-published decision on that, please shoot it over to me. I hope Ocean Club does not wind up taking the hit for the 500. meaning that the $500,000 gets distributed as a special assessment to the membership. That would be painful, right? I mean, but I also would say this. So, and again, going back to my conversations with Damon, the D&O insurance is not something that insurance companies make a ton of money on. Generally speaking, the premiums are relatively small, and they hope that the claims will be relatively small as well. I would say that if we see additional claims like this coming up in New Jersey, and the law does not change, you can be sure that the D&O policies will be changed by the carriers, because the carriers are not going to be up for unlimited bloodletting because board members are fighting amongst themselves. The policies will change. And just as a footnote on that, I'm glad you reminded me. Oftentimes there is an exclusion in policies for insured versus insured fighting, right? So I don't know why the defense was covered in this one, perhaps just the defense, and then to Janice's point, perhaps not the liability, the 500,000. But generally speaking, policies will not provide defense or coverage if an insured is suing an insured under the same policy. The reason for that is insurance carriers consider that a moral hazard. And when you say moral hazard, there's a risk that the insured and the insured would collude and sue each other to make a bunch of money. So that's why there's typically an insured versus an insured exclusion to prevent that type of collusion and moral hazard. It can be very challenging. So there is a good chance, again, to I think it was Janice's point, that the 500,000 will not be covered. I don't know yet, but and the membership will have to suck it, which is awful, right? No one likes to hear that. Oh, we got a couple more. Are board members who have served their term and no longer on the board, are they covered by insurance if someone sues them for past actions? I'm not an insurance expert, but so I'd have to look at the actual policy. So typically the answer is yes. Typically the answer is yes. It's much more complicated than that because D&O policies are generally claims made policies, I believe. Yeah, claims made policy. So the insurance is covered when the claim is asserted. So it gets a little challenging as to determine which policy covers what. But yeah, again, based even on this indemnification language documents, no one would serve on the board if the moment they stepped off the board, they were sued and they were hung out to dry, right? By reason of his or her being on the board or having been a trustee or officer of the association, except to matters which or she'll be finally judged to be acting in bad faith. So it generally applies to being board members, sitting committee members, and people volunteering for the association. Most association documents also provide for insurance coverage for the management team as well. Okay. Are they, Janice mentioned they used an attorney that was not provided by the insurance. They used the association's attorney. Right. So you can use the association's attorney to defend or prosecute an action. Generally speaking, in our practice, if we get a claim against our clients and there is insurance coverage, we will direct management and the board, or suggest management and the board turn it over to the insurance carrier and have the insurance coverage appoint insurance defense counsel, because then it's not being paid out of pocket as you go by the association. There are arrangements, we have not done this, but we would consider this. There are arrangements where the association insurance coverage, insurance defense policy will pay, say, half of the association's regular counsel fee. And if the association wants to keep us involved as the defense counsel, the association will pay the difference. You see what I'm saying? The difference between the association's counsel hourly rate and what the insurance company usually pays its hourly rate. Typically, insurance companies, with respect to insurance defense, pay a much lower rate to their insurance defense counsel than an association would pay a law firm like ours, because the insurance company counsel generally has a continuous pipeline of work to those insurance attorneys. And in fact, some law firms that work for insurance defense companies, work as insurance defense attorneys, are what people refer to as captive law firms. That's all they do. That's all they do. They do insurance defense for one particular insurance carrier or one particular type of insurance defense. So these are all interesting points and really important points, and in a lot of ways scary points. But so I hope some of you will be talking to us and your other attorneys, if you're not working with us, about whether or not we should consider amending the governing documents, whether or not we should be looking at our D&O coverage to make sure we have coverage, and make sure there's not a funky exclusion in coverage that would somehow bounce the association out of coverage under the insured versus insured exception. As I said, typically, historically, that exception was included. So generally, it's a good idea, and I even like to do it in an open meeting. We have wonderful insurance agents in this industry, right? Very super knowledgeable, very well educated, very, very experienced. And I'm a huge advocate of bringing the insurance broker in, and they do this for free. For those of you who, I could rattle off names and names and names, but probably the first person I ever met in the industry was Debbie Pasquarello, and she's an insurance whiz, right? And she will be more than happy to come to your, as are the other ones, the various Ryans. I think we have a few Ryans in the insurance brokerage business, and the other ones who are also fantastic, to come into your community open session and talk about what coverages the association has, why it's important, why it's a mistake to think that you can just sue the association and it's not a big deal because the association doesn't have to pay. I'm just hitting your insurance policy, blah, 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 right? Because, better than I can, better than the board can, the insurance carrier can explain things like loss runs, claims histories, where your premium comes from, and why, and some of my clients are here, why we're in excess lines coverage and why your insurance premiums doubled or tripled because of your claims history. So that's a very good point, Heather. Thanks for reminding me of that. So I'm a big fan. Bring your insurance person out. I think once a year. They don't charge for this. They don't charge for it. It's part of what they do for a living. And it can really help educate both your board and the membership themselves as to why is insurance important and why you should not do stupid things with respect to your association, like suing because you feel like it. Sorry, I missed the beginning of the presentation. Is the recording viewable? Yeah, it's viewable. Thanks for the question, Eric. We will have a recorded version of this going out probably someday next week. But so thanks everyone for coming. I hope you had fun. It wasn't like the most joyous, joyous first Friday with Fran, but it's great seeing everyone, and I hope you have a wonderful weekend, and I hope you all stay warm. Thanks again for attending. Bye-bye.
Have a good weekend.